and thank you for joining us for today's webinar, The Changing Landscape of Age of Criminal Responsibility Policies in the U.S. and the Steps States are Taking to Prepare for and Implement Policy Changes. My name is William Moore, and I'm with OJJDP's National Training and Technical Assistance Center. As your technical host, I would like to take a couple of minutes to discuss a few features of the Adobe Connect webinar platform and provide a few announcements to keep in mind. Please note that this event is being recorded and will be published on OJJDP NTTAC's YouTube page. The webinar recording will be archived on OJJDP NTTAC's YouTube channel, where you can also view past webinars. For the event transcript and supporting materials, please contact the OJJDP TTA Help Desk. For those wishing to download a copy of the PowerPoint slides and other important documents, you may do so by locating the handouts pod directly above the chat area. Here you will also find an FAQ for webinar participants that will likely address technical related questions. Click on the name of the file and then click the download button. There will be a Q&A session where the presenters will address some of the questions posed during the presentation. Please type your questions into the chat box as they arise. And thank you for those who are typing in the chat box now. For those of you participating in today's webinar as a group, please take a minute to help us count. Go to the chat window and type the total number of additional people in the room with you today. If you are viewing alone, there is no need to type anything into the chat pod at this time. And I'll just give our audience a few seconds to do that. Again, type in the additional number of people that you have in the room. If you are viewing alone, no need to type anything into the chat pod at this time. At the conclusion of today's webinar, you will be provided with a link to a brief survey about today's presentation. The feedback you provide is used to assist in future planning and training. Following today's webinar, attendees will be sent a certificate of attendance. This certificate is sent approximately 1 hour following the conclusion of the event and is sent via Adobe Connect thank you email. Please keep an eye on your email for your certificate. I will now turn it over to our moderator, Dr. Katie Penkoff, for today's webinar.
Thank you so much, William, and thank you everyone for joining us today. We're thrilled to see so many people were able to attend. As William said, my name is Katie Penkoff, and I am the Project Director for the Age of Criminal Responsibility Training and Technical Assistance Center at the American Institutes for Research. Our mission is to provide states with an age of criminal responsibility set under 18 and those who've recently raised the age with the research and data needed to make informed decisions about their justice policies and implementation strategies. The center is operated through a cooperative agreement with the Office of Juvenile Justice and Delinquency Prevention. As such, we are restricted from engaging in any activity that could be considered lobbying. Thus, the content of this webinar and the training and technical assistance available through the center are offered as a service to help states make informed decisions and shall not be construed as the center or OJJDP support or opposition to the enactment, repeal, modification, or adoption of any law, regulation, or policy. So with that said, thank you again for joining us for our 5th and final webinar in the series. As William mentioned, the other 4 previous webinars are housed on OJJDP's NTTAC's YouTube page. Our subject today, of course, is the changing landscape of age of criminal responsibility policies in the U.S. and the steps states are taking to prepare for and implement the policy changes. In this series, we really strive to include the perspectives of stakeholders who are impacted by age of criminal responsibility policies. The first 4 webinars in the series featured law enforcement, the National PREA coordinator, a young man who was in the adult system as a juvenile, a family advocate. We were fortunate to have the Campaign for Youth Justice, Justice Policy Institute, as well as William Carbone with the TOE Youth Justice Institute with us as part of this series to really get a full perspective of how these policies impact the different stakeholders who are involved. So for our learning objectives today, we will hear from stakeholders in states who've recently raised the upper age of juvenile court jurisdiction. Additionally, while they're still exploring their justice policies or working to implement recent changes, states and local jurisdictions are taking stock of the current programs, services, and opportunities, and are working to identify those that will be needed to serve older youth that their systems will soon absorb. Thus, in this webinar, we also hope that folks will learn about how states are preparing to implement for the policy change and raise your awareness of and utilization of existing resources to support states and local jurisdictions in these efforts. These youth that we serve are the collective responsibility of our entire community and not of any one system. So, in May of 2016, when the Office of Juvenile Justice and Delinquency Prevention released the Age of Criminal Responsibility Training and Technical Assistance Solicitation, 9 states had an age of criminal responsibility set younger than 18 years of age. Then in 2016, South Carolina and Louisiana raised the upper age of juvenile court jurisdiction. In 2017, New York and North Carolina followed suit, leaving no remaining states that automatically classified 16-year-olds as adults in the justice system. And then in just June of this year, June 1st, 2018, Missouri became the 46th state to raise the age, leaving only 4 states with an age of criminal responsibility set at younger than 18. So the landscape is definitely changing. So joining us as presenters for today's webinar are William Lassiter, the Deputy Secretary for Juvenile Justice within the North Carolina Department of Public Safety's Division of Adult Correction and Juvenile Justice, Marcia Hazelhorst, Executive Director of the Missouri Juvenile Justice Association, and Scott Odom, the Deputy Director of the Division of Youth Services within the Missouri Department of Social Services. In just a few moments, we will provide a more thorough introduction of Mr. Lassiter, Ms. Hazelhorst, and Mr. Odom, their roles within their respective states' juvenile justice system, and their involvement in exploring age of criminal responsibility policies. We will first introduce Mr. Lassiter and ask him to share his perspectives on the recent changes in North Carolina. And then after Mr. Lassiter, we will turn to Ms. Hazelhorst and Mr. Odom. We only have a bit of time with Mr. Lassiter today. As you can imagine, he's a very busy man. And so his portion will be first. We will try to address a couple of questions in the time that we have with him. In the event that we aren't able to get to all of the questions, we will make sure that we hold on to them and then follow up via email with those questions and potential responses to those questions. So, during the 2017 session, North Carolina raised the age of juvenile jurisdiction for nonviolent crimes to age 18 as part of the state's Juvenile Justice Reinvestment Act that will be effective December 1st, 2019. We are pleased to have Mr. William Lassiter, who was actively involved in North Carolina's efforts, with us today to share his perspective on the state's recent policy change. And given Florence, we're even more thankful and fortunate to have him here today with what North Carolina has been through and continues to go through. So Mr. Lassiter plans and directs operations of the Juvenile Justice section of the North Carolina Department of Public Safety and serves as a member of the department's senior leadership team. As Deputy Secretary of Juvenile Justice, he oversees juvenile facility operations, juvenile court services, juvenile community programs, and juvenile intervention and treatment programs. There are more extensive bios for each of our presenters in the handout pod. You will thank you for joining us today and sharing your perspective, Mr. Lassiter. We're now going to turn the presentation over to you. I will be asking you questions and then seeking to learn your perspective on those questions. So can you please share, Mr. Lassiter, how you were involved or your role in exploring age of criminal responsibilities in North Carolina?
Yes, good afternoon, everybody, and thank you for joining the call today. I think this is a very important topic and one that we've been exploring in the state of North Carolina for at least the last 20 years. In 1999, we passed the Juvenile Reform Act in our state that really changed the landscape of what juvenile justice looked like, that reduced the number of kids that were served in what we call youth development centers, which are our committed facilities for juveniles. That was done by a task force that was put together back in 1999. There were 40 major recommendations made at that time of how to reform the juvenile justice system in our state. And the only recommendation that was not acted on at that time was the Raise the Age initiative, or raising the age of jurisdiction to 18. Since that time, that issue has continued to be studied in our state, and I've been a part of those discussions. We've had numerous task force, study commissions, groups come in and studied the issue for us, cost-benefit analysis that have been done of the issue, a youth accountability task force that made recommendations, legislative study groups that have made recommendations, and our department obviously has been a big part of that because it affects us greatly about which population will be served in our juvenile justice system moving forward. And over the last couple of years, I specifically have served on the Chief Justice's Commission that really led the way in making some of these changes that made the recommendations about what the final legislation should look like. And we also had a large mental health and substance abuse task force that looked at the same, a number of these issues also, and I oversaw the youth and family portion of that task force. And so both of those task forces made it their #1 recommendation that the age should be increased to age 18.
Thank you very much, Mr. Lassiter. Can you share the other stakeholders who were involved in exploring North Carolina's age of criminal responsibilities? What were some of the stakeholder groups or agencies that were involved in these processes?
Sure. We had all three branches of government involved. So the Chief Justice's office was greatly involved. They put together a commission on the administration of law and justice. That commission made a number of different recommendations, but the #1 priority that came out of it was to raise the age of juvenile jurisdiction to 18. That commission alone had 80 different members on it, from the business community, from law enforcement, from judges to people, just victims' rights, people from the victims' rights community. So we had the Chief Justice on the judicial branch, and that commission, we had the governor's office that was involved for the mental health and substance abuse task force, but also for their advocacy of changing the policies in the state of North Carolina. And then we had the General Assembly that had their own study commissions that looked at raising the age, and were a huge partner in the process of making this final change. Ultimately, at the end, we had quite a few stakeholder groups that bought into this policy. The Sheriff's Association of North Carolina, the Police Benevolence Association, the North Carolina Chamber of Commerce, Conservatives for Criminal Justice Reform, which is an advocacy group that's strongly was voicing support for this policy. On the other side, we had the ACLU that was also supporting this policy. We had school administrators, the School Administrators Association. We also had the County Commissioners Association that ended up supporting the policy. And that's just to name a few of the groups that were out there. Jesse Smith, who works with the UNC School of Government, really oversaw that process and brought all the stakeholders together for that Chief Justice's Commission. And so the UNC School of Government was a very important player in the process too. But lots of stakeholders that were very important to the process, and we really had it was a very bipartisan effort. When it passed the House in the state of North Carolina, it passed 104 to 6. And that is in comparison to years past where this policy had failed to pass the legislature. So a very bipartisan and compromised policy that came together to support Raise the Age.
Thank you very much. It definitely sounds like you had a diverse group of stakeholders from all points of contact within the juvenile justice system and beyond, from early intervention all the way through. And so you mentioned that this was a policy change that North Carolina has been exploring and many have recommended for years. What were some of the major questions that needed to be answered or issues that needed to be addressed for this policy change to occur or to be successful this past year?
So I think the two biggest ones were public safety, and number two was resources. And so I'll start with public safety. Obviously from the law enforcement perspective and from some of the victim rights groups' perspectives, their concern were what about the very serious and violent offenders. And so one of the protocols that is in the policy that we put together in the final legislation was that those cases would still be transferred to adult court for kids that were over age 16. That really brought the public safety concerns down for law enforcement and for the victims' rights community and for a number of our judges that were concerned about that. So public safety was one of those issues that we really wanted to make sure that people felt safe with the policy that we were putting forward. But we also had the research that backed up the fact that juveniles served in the juvenile justice system have better outcomes than those same juveniles going into the adult system. And we presented that data through the Chief Justice's Commission, but also to the legislator and to a lot of these other policy groups. And I think that really drove the point home to folks. If you are interested in changing behavior, the juvenile justice system is better suited to working with this population because we have the professionals and the expertise in those areas to work with this population, where if they're in the adult system, they may be housed with older adults and working with people that do not have expertise in working with juveniles. And so we were able to present some of the recidivism rates. The average reduction in recidivism was 12.5% by serving a kid in the juvenile justice system versus putting them in the adult system. And I think that went a long ways also to convincing people this is actually really good for public safety in our state. Number two was resources. If we're going to do this and do this correctly, we want to make sure that the resources are available in the juvenile justice system to serve this additional population. And so the legislator actually ended up putting this as part of their budget bill to address the fact that they understood that we needed resources to make this work correctly. And it's not just about resources for the deep end kid, for the kid that's in a committed facility, but it's also for those younger folks and for the 16 or 17-year-olds that we can do early prevention with. And so we want to make sure that we have early prevention dollars that are available through what we have in our state are called juvenile crime prevention councils, that we send money to each county in the state of North Carolina to put in place a continuum of services that can serve as an alternative to detention or commitment. And so those resources are a big part of the equation. There's still a number of resources that we need in the state of North Carolina that we are hoping that the legislator will help us with next year before this fully goes into effect in December 1st of 2019.
Okay, thank you so much, Mr. Lassiter. And I think you've led perfectly into my next question is, now that the legislation has been passed, what are the questions or challenges that will remain that need to be addressed or solved to prepare for and implement the policy change? So you said, obviously resources is one kind of question
Absolutely.
or challenge.
Yeah, so resources are a big question that still remains. The legislator has started appropriating funds to the department to address some of those resource concerns. We are building an additional youth development center for the older population. That process has started, and the legislator has given us the full funding to do that with. They've also appropriated additional dollars for us to have additional juvenile court counselors, which in our state is equivalent to a probation officer. It may be in other states, but we call them juvenile court counselors. We did get 65 additional juvenile court counselor positions to start out with that we can hire this year, even before the implementation goes into place. We did that so that we could get that staff up and trained and ready to go by the time implementation comes into play. But in addition to that, we are looking for an additional about 200 juvenile court counselors across the state to deal with the additional population, and then additional community-based resources. There are a couple of other issues that we're still considering in the state. We have a juvenile jurisdiction advisory committee that was named in the legislation. Is also looking at these issues. A couple of those include reverse waiver. Reverse waiver would be for a 16 or 17-year-old that was automatically transferred to the adult court system, but that may not be the most appropriate placement for them because they fell into that A through G felony category in our state, which are the most violent and serious offenses. If, for example, they were developmentally delayed and it would be more appropriate that they were served in the juvenile jurisdiction, then reverse waiver would be a policy that would allow for those juveniles to come back into the juvenile justice system. That was not currently in the policy right now or in the legislation, so we're making recommendations to the General Assembly this year to include a reverse waiver policy. There was also a policy that was included in our legislation that we're still trying to work out, and it's once an adult, always an adult. And we really did that to make sure that we wouldn't have a whole wave of kids grandfathered back into the juvenile justice system when this went into place. So if you're already in the adult system, you would stay in the adult system even after December 1st of 2019. So in the meantime, we want to look at expungements and other opportunities to remove the record for those 16 or 17-year-olds that were going to be in the adult system moving forward that would benefit from expungement and don't have more serious offenses down the road. So we're looking at expungement policies for those juveniles. And the last one that we're really looking at is for this population that is transferred to the adult system, until they are actually adjudicated and convicted and sentenced in the adult system, what do we do with them? How do we house them moving forward? And so we are looking at actually having transferee facilities for those juvenile populations so that we can still separate them from the older population, but until they're actually deemed to be an adult by a conviction in the adult system, we want to keep them out of the adult jails across the state, mainly because what if their charges are dropped or dismissed moving forward? We don't want to expose them to the adult facilities until that process is fully taken place. And so those are some of the major challenges that we're currently considering right now in the state of North Carolina.
Okay, thank you very much. And I think you already spoke to the other policies that might be impacted by raising the age of criminal responsibility that may warrant review. And you also mentioned the committee that was put into legislation to help with the planning and oversight for implementation. Can you tell us about the different committees that are a part of that overall committee, the subcommittees, if you will?
Absolutely. So part of the legislation formed a Juvenile Jurisdiction Advisory Committee. That Juvenile Jurisdiction Advisory Committee has 21 different members on it that were appointed by the legislator. And some of them were appointed by the governor, and a couple of the members were appointed by the Chief Justice. So we've got all three branches of government represented on that Juvenile Jurisdiction Advisory Committee. We have three major committees that are working with that Juvenile Jurisdiction Advisory Committee. One is looking at legal and legislative recommendations to update the legislation. The second committee is looking at housing of juveniles, especially that transferee population, and where best to house them across the state of North Carolina to keep them separate, sight and sound separation from the adult population. And then we have a third committee, subcommittee, that's working on that Juvenile Jurisdiction Advisory Committee that's looking at the school justice partnership. Part of the legislation that was passed for our Raise the Age initiative in the state of North Carolina was looking at the school justice partnership, where we're looking at how do we reduce the number of school-based offenses coming into the juvenile justice system in the state of North Carolina. And the reason why that was included was 41% of all juvenile complaints in the state of North Carolina last year initiated from a school campus. And some of those were very low-level offenses, such as simple affray, disorderly conduct, and we really want to look at, are there better alternatives rather than throwing those kids into the juvenile justice system to serve them in school-based discipline or alternative programs that they may have at the school-based level. And so that's why we have the third subcommittee that's looking at that issue. We're putting together a toolkit that will go out to school districts and to law enforcement and to our juvenile justice staff across the state to address how do we want to set up that school justice partnership in each of our jurisdictions in the state.
Right. Thank you very much, Mr. Lasser. And I should mention we have a link later in the presentation to the committee as well as the subcommittees and the resources that are housed there. North Carolina is being very transparent about the process and sharing the process with all stakeholders who might be interested. And Mr. Lasser, I know we have just a couple of minutes of your time left. We have a couple of questions that came in for you. One is, how was recidivism measured and for how long were the youth followed in the recidivism study in North Carolina?
So our recidivism is studied in the state of North Carolina through the North Carolina Sentencing Commission, and they do recidivism studies both for the juvenile system and for the adult system. In our state, recidivism is studied for 3 years, so it's probably the longest length of time that I think any other state in the country looks at that issue. And we look at recidivism as not even just being convicted again, but actually any future involvement with the juvenile justice system or the adult system. So we specifically looked at any additional charges the kid picked up or an arrest in the adult system once they went into the adult into adult jurisdiction. So it's a 3-year process, and then we looked at even any future involvement with the juvenile or adult system.
Thank you very much. A second question that came in is, what was the estimated increase in caseloads for the juvenile system?
So what we found was, when we studied it, was about a 60% increase in the number of juveniles that will be served across the state of North Carolina based off of the data. And what we did is we actually went and looked at all the charges that were filed on 16 or 17-year-olds last year in the state of North Carolina, and then converted those into how we felt they would be disposed in the juvenile justice system. One of the unique things that we have in the state of North Carolina is that our court counselors have the authority to divert cases. And so we looked at how many cases we thought would be diverted, how many we thought would be approved for court, and then what we thought the disposition would be for those juveniles moving forward once they got into the juvenile justice system. It ended up being around 60% increase overall in the caseload. We don't think that will ultimately affect the caseloads for our juvenile court counselors because we hope to hire the additional staff to keep the caseloads in our state around 25. And I know that's maybe lower than some other states that are out there, but we've really gone to an intensive case management model with our court counselors where they're providing services to juveniles on an intensive level, making sure that they have everything that they need to be successful moving forward so that they do not recidivate back in the system. We found that purely providing supervision to kids doesn't reduce recidivism. It's actually the case management and the services that you provide with that supervision that really drive down the number of chances for that child to recidivate in the future.
Thank you so much, Mr. Lasser. It's been important for, I think, attendees to hear how North Carolina has used state, local, and national data and research to inform every stage of the process, from exploring the policy change to now working toward implementation. So we thank you so much for your time today and for your sharing your perspective and your progress in North Carolina. And if we have any further questions that come in later in the presentation, we'll make sure to share those with you. So thank you again, Mr. Lassiter.
You're welcome. Thank you.
And now I'm going to ask similar questions of our next presenters. And I have somewhat of a lengthy introduction only because I want to provide some context to how the Missouri juvenile justice system works as I introduce our presenters. On June 1st of 2018, Missouri Senate Bill 793 was signed into law. This act provides that unless the child is certified as an adult or is being prosecuted for a traffic or curfew violation, children who are 17 years of age must be prosecuted in the juvenile court system. The new law goes into effect, as Cheryl mentioned in the chat box, on January 1st, 2021. We are fortunate to have Marcia Hazelhorst and Scott Odom with us today to share their perspectives on Missouri's recent policy change. Missouri's juvenile justice system is bifurcated. The county level circuit courts are responsible for youth from initial referral to court through disposition, And then the Missouri Department of Social Services, Division of Youth Services, is responsible generally for youth from commitment through aftercare. Ms. Hazel Horst is the Executive Director of the Missouri Juvenile Justice Association. She is also the Juvenile Detention Alternatives Initiative Coordinator from Missouri and a 2013 graduate of the Annie E. Casey Foundation's Applied Leadership Network. Previously, Ms. Hazel Horst worked for the 13th Judicial Circuit Juvenile Division for 17 years, holding several positions within the court, including Deputy Juvenile Officer, Supervisor, and Detention Superintendent. The Missouri Juvenile Justice Association, or MJJA, is a statewide not-for-profit organization whose mission is dedicated to promoting justice for children, youth, and families within Missouri. MJJ envisions a preferred future in which the public is aware and supportive of the delivery of quality juvenile justice services to the children of Missouri. The association and its members represent stakeholders from all points of contact of the justice system, from first referral to the juvenile and family courts to youth certified as adults and served by the Missouri Department of Corrections. Much of Missouri Juvenile Justice Association's membership base are representatives from the county and family courts. These local juvenile and family courts are considered the front end of Missouri's system. Scott Odom is the Deputy Director of the Missouri Department of Social Services Division of Youth Services. Division of Youth Services, or DYS, is considered the deeper end of Missouri's system. And according to the Missouri Department of Social Services Division of Youth Services website, the Division of Youth Services, or DYS, is the state agency charged with the care and treatment of delinquent youth committed to its custody by one of the 45 Missouri juvenile courts. DYS programs are established to provide the mandated services that are enumerated in statute of the state of Missouri. The services include assessment, care and treatment, and the education of all youth committed to its care. For this end, DYS operates treatment programs ranging from non-residential day treatment centers through secure residential institutions. Additionally, DYS administers the Interstate Compact on juveniles, operates an accredited school program, and maintains statewide statistical database of juvenile court referrals. DYS is administratively organized into one central office with 5 regional offices. Mr. Odom has 25 years of service with the division, and over the course of his career, he's held many field-level positions in both residential care and case management across multiple regions of the state. So in addition, he has the direct service as well as the administrative experience with the Division of Youth Services. So I say all of this to share that today, Ms. Hazel Horst will be sharing the perspective of the Juvenile and Family Court Divisions of the Circuit Court, or the front end, and Mr. Odom will be sharing the perspectives of the Department of Youth Services, or the deeper end of Missouri's system. So again, thank you so much for being with us today. We really appreciate your time and perspective, and I think I will then now move to our questions. Marcia, perhaps I can start with you. Can you please share your role in exploring Missouri's age of criminal responsibility policies?
Sure. Thank you, Katie, and welcome everyone participating in the webinar. We're excited to have so many people joining us today. So I have actively worked on raise the age legislation for the past 4 years. We've had a bill filed at least each year for the past 4. And so I generally have advocated for the passing of Raise the Age and represented, as you mentioned, many juvenile and family court and folks that are members of Missouri Juvenile Justice Association. So I've testified multiple times, attended many various meetings and group opportunities to move Raise the Age forward, and obviously had many meetings with legislators over the years, and did my best to work with the various partners and groups also working on Raise the Age. And I also should mention that Missouri actually in 2008 had legislation filed at that time that addressed raising the age, but it did not pass entirely in terms of addressing delinquency. It raise the age for 17-year-old status offenders, and that was subject to appropriations, and it's never been implemented. So it's actually been on our books since 2008, but never was implemented due to funding. So there was that attempt several years ago. It just did not make it to the finish line. And while I was a deputy juvenile officer at that time, I wasn't actively involved in that legislation, but I know that MJJ was.
Thank you very much, Marcia. Important to know about the history there. Scott, now if I could ask you how you've been involved in exploring Missouri's policies.
Yeah, so for me, thank you. Thanks for the introduction, the kind words, and good to be with everyone today. Sort of in on the ground floor, beginning in 2014, there was a legislatively organized task force for this issue. Some juvenile justice reform, raise the age being one big chunk of that. And I believe Marcia was a part of that task force at the beginning, although I don't recall. But it was a cross-section group, lots of folks represented, the Association of Prosecuting Attorneys, the Public Defender's Office, Children's Division, DYS, our Office of the State Courts Administrator, legislatively led, and then our Department of Public Safety were a big chunk of the participants. I was the deep end of the systems representative along with our director in those conversations very early on, and that task force led ultimately to the drafting and filing, I think, of the bill, I want to say 2015, the filing of the first Raise the Age bill. So I've represented DYS's interest in those conversations or been part of a team that represented those from the beginning of this last effort that ultimately resulted in the passage and enactment of Raise the Age Now.
Thank you very much. Since you've both been engaged in this process, have the composition of the stakeholders who've been at the table to explore the policy changed over time? Have different people come to the table who may not have been there previously?
Yes, there's been, we've had various different stakeholders over the years, but this year we had a few new stakeholders that while they may have certainly been watching the bill and having conversations, I don't know that they were actively at the table working within our various groups, and those included, this year we had a couple new advocacy groups from Missouri, Empower Missouri, Kids Win Missouri, who were both pretty instrumental in participating in helping to get more of the partners together and on the same page. We had the Public Defender, Missouri Association of Counties, we had Presiding County Commissioners Association, Missouri Coalition of Children's Agencies, and I mean those were some of the newer stakeholders, but we also have always had law enforcement, Office of State Court Administrator, DYS, MJJ, and prosecutors, Missouri Association of Prosecution Services, again, have always been engaged, maybe not actively in attending our regular meetings, but always following the legislation and having conversations with partners.
Thank you, Marcia. Scott, anything to add?
No, that was a comprehensive list of, I think, of the folks that have been sort of constants throughout. As Marcia indicated, I think different advocacy groups, they played early roles in sort of moving this idea and the concept. And then last year, there were groups that joined, local groups that I think really pushed forward, and ultimately this was the year that it worked. So.
Thank you. And in our conversations, I have learned that many stakeholders in Missouri developmentally felt that raising the age of criminal responsibility was the right thing to do for Missouri. However, there were some questions or issues that needed to be addressed for different stakeholders to feel comfortable with that policy change. What were some of the issues or concerns that needed to be addressed, that were addressed this time, that led to the policy change?
Well,
So,
go ahead, Mark.
No.
Well, I would just say early on, so I'm just remembering back to the original task force back in 2014. I just remember, generally speaking, I think there was some trepidation in the room from different parties, but in general, it wasn't difficult to get consensus around the idea that it was good for children, good for kids in the system. I think, it's not going to be a big surprise to anybody on the phone that, and as Mr. Lassiter mentioned, resourcing it properly and not sacrificing what people believe to be a really good system in order to pursue this next piece. And if it was under-resourced and underfunded, that we would be sacrificing good pursuing this next piece. And I think I feel pretty comfortable saying that generally that was a sort of a tenet running through the group, is that the concerns about resourcing it properly and having a time to implement well were the concerns faced by most.
Yes,
Marsha, you can add to that.
Yeah, I would agree completely, Scott. Really, I'm thinking back into even the early, the first year the bill was filed. Public safety, that wasn't really, wasn't a large part of our conversation. It wasn't a big part of our conversation.
Mm-hmm.
I think, again, everyone conceptually agreed 17-year-olds would be better served in the juvenile justice system. We just could not come to some consensus on what this might entail or cost. We had some stakeholders that maintained that there would be no cost, no cost at all to serve 17-year-olds in the juvenile system. Some felt it would be just a shifting of funding from one state agency to another state agency. For example, shifting funds from our State Department of Corrections that currently serves 17-year-olds over to our judiciary system or to the social services where Scott is at. So the problem with that is that, as you mentioned a little bit, Katie, in the introduction, the budgets for funding our system come from both state and county dollars. And we have 46 judicial circuits in Missouri, and 10 of those are what we call single county circuits, and they receive a great deal of their funds from their county governments. And we have multi-county circuits who their employees, several of their employees, majority, are funded through state dollars. But their county takes care of all their operational costs. And we have county-owned and operated juvenile detention facilities. So, we had just a combination of funding that went into the system, and so it wasn't just, you couldn't just easily say you could shift these dollars from one state department to follow the 17-year-old into a new system. And for years we've had fiscal notes that have ranged, from $10 million to $14 million on up, and we always seem to be stuck on some groups saying, those are inflated fiscal notes. Some saying, those aren't, high enough. We just didn't know exactly what the cost was going to be, but we couldn't agree that conceptually until this year we could not agree that there would be a cost. So. Yeah,
I would add to that. This was all happening at a pretty unique time. I mean, for us, DYS, we have some ownership and will continue. I think, so a couple things fed this. We had significant data gaps, I think, across the system because of the bifurcation in the independent county databases, 45, 46 different databases with county jail populations. And that data gap fed, the speculation about the numbers of kids that would be coming. That seemed to always be sort of a big question mark about how to account for that and whose estimates could you take forward. And I think from our end, just the deep end perspective of operating residential programs and 30 of those across the state, we landed at a figure or an estimate, but the challenge was we were in a time where our population was shrinking. And so in 2015, when we reported significant cost, we were very supportive of the concept and the bill and wanted to do it, but we couldn't, rightfully go forward in support of the bill without asking for the resources to implement it appropriately. And so in 2015, our cost was estimated to be really high. As the years went by and the legislation was filed, we saw significant, like most across the country, reductions in the number of youth coming into care. And so by the end and enactment this year, our fiscal note shrank dramatically to the point where, we were very conflicted. We were having to reduce our current platform and resources in a time where we were speculating about adding a whole new segment of kids to the system. And so how do you responsibly shrink while you're anticipating growth? And with the way the budget process works, and that was a really complex sort of labyrinth to navigate. But we're here today. It passed this year, and we're going to move forward with our estimates and planning for funding. And we can talk a little bit more about the funding piece as we go.
Okay. I think that brings us to a great point. Now that the legislation has been passed, what questions or challenges that remain that will need to be addressed or solved to prepare for or implement Missouri's change?
Yeah, so for the deep end of the system, for us, quite a bit. I mean, I think while, folks have settled on the speculative estimates, I don't think anyone in this process is absolutely certain what this means in terms of the number of young people coming into care to the deep end. And so we're trying to remain as flexible as we can, preserve existing resources, and have the opportunity to communicate with regularity to our department and the legislators, bill authors, the potential need for funding as we go forward. Our bill, and Marcia can talk more about this, because right now the way the language is set up, the deep end is excluded from the new monies, but the bill actually set up new funding streams into a juvenile justice preservation fund that will be available to the local judicial circuits for implementation. We were left out of that. So we suspect that there'll be needs going forward, and we're in the process of wrangling through what those might be. I think for us immediately, the way the bill is written, and this is a fairly complex thing to explain, but as the law is written now, young people between 16 and 17 have original jurisdiction in juvenile court. If they're committed for a crime during that time, we still work with those young people and have statutory authority to work with them until they're 18 years of age. So at present, we are serving many 17-year-olds up to 18. So in some ways, that doesn't change for us. We have those young people in residential care centers where they're on aftercare in the community. Changing the criminal age of majority to 18 introduces, for new crimes committed between 17 and 18 now, that jurisdiction will lie in juvenile court, and those young people may be committed during that time to us. What the new law hasn't done is give us that grace period to work with those young people until they're 19. So as it stands right now, the law doesn't change a whole lot for us, but we will likely pursue a change to what's been passed to allow us to work with young people until they're 19. we always have the option of petitioning the courts to extend our jurisdiction to 21 for youth committed to our care, but that's not going to be an efficient way to deal with a host of new kids coming into the system. I think the other thing that continues to sort of warrant attention and concern is Missouri worked really, really hard. In 1995, the crime bill passed here and created dual jurisdiction. And at that time, I want to say the numbers were in the 350s, the number of young people that were certified in the state of Missouri. Over the years, I'm really proud of our system and the work folks have done. That certification number has been reduced to about 50 over the last 3 years. It's averaged about 50. And so a lot of work has gone into reducing that certified youth number. My concern, if the law stays the way it is, that 17-and-a-half-year-olds that are facing a juvenile court judge for a new crime will look at that and say there's not time to be served in the juvenile system, and the numbers of certifications will increase, and that would be sort of collateral damage, nothing that was intended by the enactment of this bill. In fact, it would work in opposition. The goal would be is to reduce the numbers of young people in the adult jail settings. And so I think we want to be really careful with that by extending or getting that grace period from 18 to 19 with implied or explicit ability to continue to serve that population from 18 to 19 would be a nice fix there. So those are the things that we continue to wrestle with and are in the process of pursuing.
I would
Thank
say
you so much.
Go ahead, Katie.
Oh, no, go ahead, Marcia.
I was just going to add, in addition to Scott pointing out the issue with the back end and commitment to Division of Youth Services, I think we're also going to need to look at clarifying what a 17-year-old is because of the way the bill is worded. It's January 1st, 2021 is the date it goes into effect. And so there could be probably not a lot of children, but there could be the potential to have some 17, someone who turned 17 prior to the date of implementation, who then later, after the implementation date, because of the way it's worded, they could potentially be handled as a juvenile. And so we want to make sure that that wording is really clear for particular law enforcement and prosecutors and juvenile officers to know, is it going to be, is January 1, 2021 just that cutoff date where any children who, were 17 prior to that would be handled as adults from moving forward. But we definitely need to kind of look at clarifying that language a little better, because I've had several questions about that, and even several legislators, law enforcement are wondering what that might look like.
Thank you both. I think as attendees are learning, and from what Mr. Lassiter shared as well, is that once the legislation is passed, there's still much information and data and research and planning that needs to go into preparing for that successful implementation of a policy change. At this point, we just have a few minutes left in the webinar. I wanted to thank Ms. Hazelhorst and Mr. Odom for their time and their expertise and their perspective. And then I also wanted to see if there are any questions. So if you do have questions for either one of them, please place them in the chat box. And let's see here. Okay. So it looks like perhaps a resource here, Ocean County Juvenile Services, Toms River, New Jersey, FYI, for a scientific view of adolescent brain development. Oh yes, look at Lauren Steinberg and Issues in Science and Technology. So there's a resource that's being shared here. Thank you very much for doing that. As we progress through the rest of the webinar, the intent wasn't to read over all of the information here. It was to provide stakeholders who are exploring a policy change or working to implement a policy change with resources to do so. And this is informed by the work of local and state level jurisdictions working towards this policy change or exploring it, as well as a publication that just came out yesterday from the Campaign for Youth Justice. We have a link to it here at the bottom of the page, and it's implementing laws to raise the age of juvenile court jurisdiction to 18, what states and localities can do to prepare for success. And with Jeree Thomas and Marcy Mistrat, Brian Evans, and others at Campaign for Youth Justice, this publication was informed by their work with local jurisdictions and states who are exploring these very issues. So, essentially here, the point is to really engage a diverse group of stakeholders. We've heard that from each and every presenter, to really elicit the questions and concerns or issues that each group of stakeholders has, to identify, collect, and analyze data in response to those concerns and all through the process, to host regional forums to provide training on the policy changes, to inventory your current program services and opportunities and determine needed program services and opportunities. And then, as you heard Ms. Hazelhorst and Mr. Odom say, it's important to explore the potential unintended consequences of the change and to explore other policies that may be impacted or warrant review. And so for each of those areas here, we've included resources. So, one of the suggestions is to, engage with state-level groups that are already working on juvenile justice systems improvement work. So here, you've got links to your state's Title II designated state agency through the Juvenile Justice and Delinquency Prevention Act, where you can click on and find out who's involved in your state. The State Advisory Group, which is also part of that Title II Formula Grants Program and the Juvenile Justice and Delinquency Prevention Act. Links to find your Administrative Office of the Courts, which often collect the data needed. So as you go through, it has different suggestions, and I know we're running out of time, and I need to turn it back over to INTAC. But I have links here to potential data sources for both local, state, and national data, as well as information on how New York is preparing for the policy change. I have links to their website, and they've done a lot to prepare forecasts to help people make decisions, and then information about how to implement those decisions. So we've got those resources included. And so again, here just lots of different resources on services that will be needed for older youth and who you might consider partnering with. I do want to point out that we have an online community of practice that you can join that lists a lot of these resources. And then I'm going to conclude by turning it back over to INTAC. Sorry, William, to go over there a bit.
No worries at all there, Katie. And just thank you for everyone for joining us. And if everyone could just hold just for a couple of minutes, I want to send out a couple of reminders. Remember, this PowerPoint and those links that Katie just mentioned are available for handout for download right now in the handouts pod. Also contact the help desk if you would like to receive any materials or have any other follow-up questions regarding today's webinar. But again, you may contact INTAC through the website displayed here, and you can stay up to date on the latest information by signing up for OJJDP NTTAC TTA listserv. Also, don't forget to check us out on Facebook at OJJDP TTA. And then you can also contact OJJDP via the help desk for any following the contact information on this slide here if you all have any additional questions post-webinar. Just a reminder that you can view this webinar recording on YouTube. It will be archived on our YouTube channel, and the supporting resources can be obtained by contacting OJJDP's help desk as well at OJJDP@USDOJ.gov. Please take a few minutes or a few moments to review this disclaimer here. And finally, just as a reminder, please take about 5 minutes to complete the feedback survey. Thank you all again for joining us today. Have a great afternoon.
Yes, and thank you to our presenters and to the National Training and Technical Assistance Center and to all those who made the time to attend today. And please reach out, explore the resources that we've listed. Thank you so much.
Excellent.